Is naming a mosque unconstitutional? Understanding law behind the controversy. What is the Babri Masjid at Murshidabad, West Bengal? Friends, these days you must be seeing a lot of news debates about Babri Masjid.
ये नवाब के देश है, ये राजा के देश है, ये राजा से देश से मुर्शिदाबाद से ये बाबरी मस्जिद होना चाहिए।
जिस पार्टी से हुमायूं कबीर साहब चुनाव लड़ेगा हम लोग उनका साथ है। 26 में ममता दीदी का सरकार गिर जाएगा, 110% गारंटी।
It's trending across the television channels, YouTube's, paper, media, discussion, debates, social media, timelines, everywhere for TRP. But let me ask you a simple question, very important question. Is naming a mosque after a historical figure, any historical figure like Babur, actually unconstitutional? Let's discuss. The answer from a purely legal mind and constitutional perspective may surprise you. There is no direct constitutional restriction on naming a mosque after a Mughal emperor or any historical personality. I am Mithilesh Kumar Pandey, practicing advocate at Supreme Court of India and founder of Learning Bench. And in this video, I will explain the entire issue calmly, legally, and in a very simple language so that facts are separated from emotions and we are giving you true facts. Recently, a controversy emerged in Murshidabad, West Bengal, district West Bengal, in India, by suspended TMC MLA Humayun Kabir laid the foundation stone for a mosque and referred to it as a Babri Masjid because the name Babur is historically associated with the Babri Masjid dispute. The announcement immediately triggered political reactions in entire India. Some political leaders and organizations called the naming proactive, others claimed it was offensive, and some even demanded a criminal action against TMC leaders. On the other side, several Muslim religious leaders stated clearly that building a mosque and choosing its naming is allowed under the Constitution of India. Yes, it's allowed under the law. So the real question becomes very crucial, very important. What does the Constitution actually say? What does the Constitution of Bhimrao Ambedkar actually says? Understanding religious freedom. Let's begin with the most important constitutional provisions of the law. Article 25 of the Constitution of India guarantees every citizen freedom of conscience, freedom to profess, practice, and propagate religion. This freedom is subject only to public order, morality, and health. These are three conditions. Then come Article 26, which gives religious communities a right to establish and maintain place of worship like masjid or mandir, whatsoever. All the articles in the Constitution gives you several rights. Right to speech, right to follow the religion. Nowhere in article will you find any sentence, any word that says a religious place can't be named after a historical or any historical personality. So from a constitutional standpoint, naming a mosque but naming a masjid is part of managing religious affairs, which is allowed in the Constitution as long as it does not violate public order or laws. This is why religious bodies, including the All India Imam Association, have stated that such naming is not unconstitutional. ये असंवैधानिक नहीं है. Secularism and equality before law is very important. India is a secular republic. Under Article 14, the Constitution guarantees equality before law. We are well aware with these facts. This means we people of India is supreme. The state cannot favor one religion over another. Religious freedom apply equally to all communities, all people. If temples can be named after sons, gurus, or historical favor, then mosques and churches are entitled to the same constitutional protection. Yes, it's true. A controversial name by itself does not violate secularism. Please keep in mind, for a constitutional violation to exist, one must prove discrimination, hatred, unequal treatment by the state. Symbolism alone is not enough in constitutional law. Public order, criminal law, and many other things Now let us address an important concern about this Babri Masjid. Now, what about public order? Let's discuss. India's criminal law now governed by BNS, Bharatiya Nyaya Sanhita 2023, and this BNS does not contain provisions to prevent this type of activity. Promotion of communal enmity, deliberate acts intended to outrage religious feelings. Sections dealing with hate speech or incitement can be invoked only if intent and impact are proven. This is important. Merely naming a mosque does not automatically satisfy these legal requirements. Court requirements? What is the court requirement? Clear intent, evidence of provocation, actual or imminent threat to public peace. That is why demands for FIR must be examined legally, not emotionally. The court has to examine the violation of law legally, not emotionally. What the Supreme Court actually decided. In 2019, the Supreme Court India delivered its historic judgment in the Ayodhya land dispute, Janam Khan land dispute. Let's be very clear about one thing. That judgment of the Supreme Court dealt with the ownership of the title of one specific piece of land in Ayodhya. The Supreme Court of India judgment did not ban construction of mosques anywhere elsewhere, restricting naming of religious places, create any rule about historical names. So linking the judgment to this controversy is legally incorrect. Is it unconstitutional? Let's break it down. My friends, to call something unconstitutional, you must show something legally, a specific constitutional provision, a clear violation of fundamental rights, discriminatory or unlawful state action. In this case, as per my understanding, no constitutional article bans such naming of the Babri Masjid. Religious freedom supports it. Equality before the law protects it. Opposition to the naming is largely politically or morally not constitutional. And courts do not decide cases on sentiments, on emotions. The court decides on law and evidence. Finally, legally perspective. From a strictly legal point of view, building a mosque is constitutionally protected. Naming a mosque is constitutionally permissible. Controversy alone does not make an act illegal. Historical sensitives matter socially and politically, but they become illegally relevant only when they cross into illegality. They enter into illegality. Many debates on television makes issues look illegal when they are not. Remember this simple rule of law. Not every controversial act is illegal. Not every emotional issue is unconstitutional. Court asks only one question. Has any law actually been broken? Yes or no? If the answer is no, then Constitution stands firm, protecting freedom, equality and democracy. Thank you for watching this video. Stay informed, stay constitutional and be with us. Subscribe Law Learning Bench. Thank you for listening me.